All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention.
Landmark Cases, C-SPAN's Special History Series, produced in partnership with the National Constitution Center, exploring the human stories and constitutional dramas behind 12 historic Supreme Court decisions.
Mr. Chief Justice, and may it please the Court.
Quite often, and many of our most famous decisions are ones that the court took that were quite unpopular.
Let's go through a few cases that illustrate very dramatically and visually what it means to live in a society of different people who help stick together because they believe in a rule of law.
Good evening and welcome to Landmark Cases. Tonight, Plessy versus Ferguson. This 1896 case established the concept of separate but equal that enabled Jim Crow segregation laws to flourish legally in this country for the next 5 decades after the decision. It didn't change in the United States until the 1954 Brown versus Board of Education decision in the Supreme Court and the Civil and Voting Rights Acts of the 1960s. 6 decades before Rosa Parks refused to give up her seat on an Alabama bus, Homer Plessy took a seat in a whites-only railroad car in New Orleans, Louisiana. And we're going to start our story tonight there. We're going to introduce you to Keith Plessy, who is a descendant of Homer Plessy, and he'll set the stage for us and our court case.
This is the location of the East Louisiana Railroad. In 1892, on June 7th, Homer Plessy approached the train depot over here at Press and Charters and purchased a ticket to board the Louisiana Railroad car, which was mandated that separate cars be established for blacks and whites. 1 block away, he was arrested at Press and Royal Streets. This was not a random act of civil disobedience. It was a well-thought-out plan crafted by the Citizens Committee, a multiracial group of citizens here in New Orleans, made up of 18 lawyers, prominent citizens who were totally against the segregation laws established by the Louisiana legislature in 1890. The conductor and the arresting officer, C.C. Kane, already knew that Homer Plessy was going to be riding the train that day. They were part of the plan organized by the Citizens Committee. The East Louisiana Railroad did not agree with segregation. His case started as a local case here in New Orleans to fight against Louisiana's separate car law. Eventually, it was moved to the state level and eventually to be known as the infamous landmark Plessy versus Ferguson case of 1896.
That's Keith Ferguson, Keith Plessy, who is a descendant of the defendant in this case, and we're going to learn more about his story as this unfolds. Let me introduce you to the 2 guests who are at our table tonight. They'll be with us for the next 90 minutes to help us understand this case, American history at the time, and its implications for our society. Ted Shaw is the director of the University of North Carolina's School of Law's Center for Civil Rights. In a prior part of his career, he was a former director counsel and also the president of the NAACP Legal Defense Fund. Did that from 2004 to 2008. The Legal Defense Fund was founded by Thurgood Marshall. Welcome to our program. Nice to have you here.
Thank you.
Mike Klarman teaches at Harvard University Law. He is a constitutional historian, legal scholar, and the author of a book called From Jim Crow to Civil Rights, the Supreme Court and the Struggle for Racial Equality. Earlier in his legal career, he clerked for Ruth Bader Ginsburg when she served on the U.S. Court of Appeals. Welcome. Thanks for being here.
Thanks for having me.
Well, we always ask the question, how did this become a landmark case? Most of the high school students who are watching tonight have this in their high school curriculum. How did it get there?
Well, it got there because, as Keith Plessy said in the video, this was a planned test case. And I think one of the things that is worth pointing out is that this case was decided in 1896. And this was the kind of final straw when it came to the end of the Reconstruction era. But it also is important to point out something that most people never heard of. That is to say, a year before the Supreme Court decided Plessy, there was a conference in Atlanta, the Atlanta Exposition, and Booker T. Washington, the most famous African American in the country at that time, spoke at that convention, the only African American, I think, to speak there. And he offered a compromise. It was called the Atlanta Compromise, which he was essentially saying to black people in the South, don't challenge white people for political power. Don't try to run for office. Don't try to desegregate schools and other institutions. Cast down your buckets where you are, he told them. Do industrial work, etc. That's something that made a lot of white Southerners feel comfortable. But essentially, he was saying to white Southerners that black people should do exactly what the Supreme Court suggested should happen a year later. I don't have any evidence that the Supreme Court was aware of what Booker T. Washington said, but I wouldn't be surprised if they were. And so this was an era in which the Jim Crow laws came into being, but it was also because of the necessity of challenging segregation laws that were already in place.
Mike Klarman, this is a 14th Amendment test. What provisions of the 14th Amendment were the questions central to this case?
Plessy is arguing that this violates the Equal Protection Clause. He's also arguing it violates the 13th Amendment. So he's arguing segregation is a badge or incident of slavery, but he's also arguing that the government ought not to be making any laws that contain racial distinctions, and for the government to do so violates the Equal Protection Clause.
These are the key dates in this case as it unfolds legally. First of all, Louisiana passed its Separate Car Act in 1890. It took 2 years before Homer Plessy's arrest, 1892, and his loss in Louisiana State Court. And then it took until 1896 for Plessy's appeal to reach the Supreme Court, and the case was decided just a month after it was heard. We're going to learn more about the history that unfolded around all of those events. But the Louisiana law, 1890, so Louisiana wasn't the first state to have a separate railroad car. What was happening in the South that these railroad car laws were beginning to be passed?
Historians disagree a little bit about how integrated the railroads were before Southern states started to mandate segregation. So I think there's some evidence to believe that you had less and less integration over time, even before Southern states began passing these laws. Florida was the first one in 1887. Then most of the rest of the South followed. There was a gap in time, and then the eastern seaboard states in the South followed beginning around 1898. But I think most historians think that already Southern life was becoming more segregated. It was becoming more dangerous for African Americans to try to mix with whites. It also made a difference. The United States Supreme Court in 1883 had struck down the federal public accommodations law, and that opened up room for Southern states to pass these segregation statutes. It probably also mattered that a Democrat finally won control of the White House again in 1884. You had a Democratic administration. This is an era when the Democratic Party was very much not the party of civil rights. The Republican Party, the party of Lincoln, was the party that was most protective of civil rights. So now you had a government in Washington, D.C. that wasn't interested in enforcing civil rights anymore, and that sort of opened the way for Southern states to try to reassert themselves by insisting on segregation.
It's worth pointing out.
One second before we do that, I want to put the text of the law on the screen so you can talk a little bit more. Just here's one provision of it. This was the 1890 Louisiana Separate Car Act. Be it enacted by the General Assembly of the State of Louisiana that all railway companies carrying passengers in their coaches in this state shall provide equal but separate accommodations for the white and colored races. You wanted to make a point about this law.
Well, I was going to point out that this was not the first time Louisiana was engaged with the question of whether it was legal to segregate people who were using transportation. I think it was 1878, but there was a case called Hall versus DeQueer, in which a black woman was taking a steamboat down the Mississippi River to get to her. She was well off. She was trying to get to her plantation she owned. And she was ejected from her cabin, first-class cabin, as a consequence of being African American. And so that challenge actually went to court, and it turned ultimately on a question that was not irrelevant to Plessy, and it turned on the question of the fact that that steamship started its journey outside of the state. And so, as a consequence, interstate commerce clause governed, and if it was interstate, it might have been a different result. Well, you had a similar issue actually in Plessy, because Plessy wasn't the first individual to challenge the railroad law that you just put up on the screen. There was another individual, but again, that trip started outside of the state, and so the same result. Plessy's case was totally intrastate, and so it raised the question, and only the question, of whether or not it was constitutional to segregate him in the railroad car under the state law.
Mike Klarman, it's really an interesting note that people should understand that the railroad companies didn't like this law either because it was expensive.
Right. So in more than one way, they might have to put additional cars on the train, and their conductors have to police race relations. And if you made a mistake, you took somebody who you thought was white or somebody you thought was black, and you put them in the other car, and it turned out that they weren't black, and they could sue you. So it could be very expensive for the railroad companies.
So after this law was passed, the Committee of Citizens was formed, and Keith Plessy talked about that. It was an interracial group in the city of New Orleans, and they hired a lawyer to help guide them through this. And this is one of the things that's wonderful about this series, because this is a gentleman who deserves a place in civil rights history. Albion Tourget is the name I'm talking about, and it's a name unknown to most Americans, I would say. Who is Albion Tourget?
Well, Albion Tourget was a white Union soldier. He fought in the Civil War and was 3 times wounded, and also, I think, served a period of 4 months as a prisoner of war. After the war, he came back to the South. He lived in North Carolina. In fact, he was engaged in some kind of tree farming business. But he also was politically active and outspoken because he believed deeply in civil rights and constitutional rights for the freed men and women, freedmen at the time. And he ran into some problems because of that, and his safety was at issue, and so he left. And he went to New York. He lived in upstate New York, and it was there, or from there, that when he heard about the Louisiana law and the challenge, the Plessy challenge, that he wrote an article about it that appeared in a Chicago newspaper. He was then contacted by the Citizens Committee because they knew this was a lawyer who had experience and could be helpful. And so he came on board and affiliated himself with the local New Orleans lawyer, a lawyer by the name of Walker, who handled the matter in the New Orleans courts. And that's how he got involved in the case.
He is described in some biographies as the nation's leading civil rights lawyer of the era, took on the case pro bono. Can you add any more meat on the bones that people should know about him?
I don't know as much about him as I would like. He was a famous novelist, so he wrote books. He wrote them anonymously because he was worried that if he affixed his name to the books he was writing, there would be consequences to pay in an era that people were apt to use violence to suppress opinions they didn't like. He sold 200,000 copies of a book anonymously, and then he wrote another book, and he signed it as the author of this first book. Wouldn't put his name on his books.
It's a nice lead into our visit to the McClurg Museum in Westfield, New York, to hear more about Albion Tourget's books. He wrote over 30 of them. Let's learn a little more about him.
Because of his relationship with former slaves during the Civil War and right after, during Reconstruction, he saw firsthand what the problems were, and he wanted to fix those problems. He started writing and did articles on civil rights and started writing books. 1879, the first book he wrote was called A Fool's Errand, and it was during Reconstruction, and a lot of people, especially down there, didn't want to hear about blacks, former slaves having the rights. So it was like a target point that made a lot of people angry. And it's so controversial that he never put his name in the book. So it's A Fool's Errand written by one of the fools. His name does not appear. It was so successful that he decided then to start writing more novels and books. And his second book is the same way. It's Bricks Without Straw by the author of A Fool's Errand. No name.
And Albion Torget argued this case before the Supreme Court. In our later on in the program, we'll learn more about the centrality of his argument. But I want to tell you that we'd like to get you involved in this program, and here's how you do it. If you live in the Eastern or Central time zones, 202-748-8900. If you live in the Mountain or Pacific time zones, 202-748-8901. You can also tweet us a comment. Use the hashtag #LandmarkCases. When you do, and we'll mix tweets throughout our program for our two guests. So Homer Plessy was a member of the Citizens Committee in New Orleans. How did he become the central figure in this case?
Ted, do you want to?
Well, after the first case, the case that I mentioned before, failed because of the issue of interstate commerce, the committee needed to come up with someone else. And he actually knew the individual who headed up the committee, and so because of that relationship, he agreed that he would be the plaintiff in the test case. The other thing that's important to acknowledge is that there was a long history in New Orleans of an African American upper class, so to speak. Relatively speaking, not upper class, but they tended to be light-skinned almost exclusively, as Homer Plessy was. This was an individual who could pass for white. That's an important part of the story, an important part of the test. He announced that he was a black man or a Negro or a colored man at the time to the conductor, and that was all prearranged, and it led to his arrest. But that was an essential part of this story and of this committee.
So he could easily pass for white, but as we said before, the train company didn't like this law either, and they were involved in helping set the test case. I read that they hired the detective that made the arrest so that he was arrested on the right charges, not for vagrancy or other things. And we saw in that video that they only went one block before the arrest was made. Is this one of the first examples of a test case going to the Supreme Court? Can you think of this as kind of a new concept for people gathering together as citizens and trying to push a case to the court?
I think there were other examples. So there's a case in the first decade of the Supreme Court in the 1790s when somebody wanted to test the constitutionality of a tax on carriages. They created a phony case and they managed to convince the Supreme Court to take it. I think there were a lot of Marshall era cases in the early 19th century where people would manage to fabricate cases in order to get something tested in the Supreme Court.
So first of all, it had to go through the state courts because it was really the state law that was being tested. This is where John Ferguson comes into the story. Can you tell us about him?
John Ferguson was the judge. He knew the case was coming also, apparently, but he was the judge before whom Homer Plessy was, I guess he was arraigned or something comparable to that. And he originally was from Massachusetts and had come south after the Civil War and married the daughter of a prominent lawyer. And he became active in state politics, and as a consequence of that activity ran for the bench and became a judge. And so that's a little bit about him.
Is it important to know what his finding was in this case and what his legal thinking was that he upheld the state law?
Oh, he knew that and ruled in a way that indicated that Homer Plessy had a tough row to hoe. That the law that was being challenged was going to be upheld, and so he ruled against Homer Plessy.
We saw in our timeline that it took almost 3.5 years for this case to make it to the Supreme Court. Part of that was some strategy on the part of Albion Tourget, hoping for a more favorable court. Can you tell us a little bit about what was happening to the court in that era?
I don't know specifically why this case was being litigated for so long. It wasn't unusual in the 19th century for cases to take a long time to get to the Supreme Court. I can think of cases in the 1830s that were first argued in 1831 but never got decided until after John Marshall had died, until 1837. It wasn't that unusual for cases to take a long time to percolate. Even today, it's not unusual for it to take a couple of years for something to get to the Supreme Court, but there might have been something specific going on. I don't know, Ted, do you know why it took that long?
Well, I think you're correct when you say that it took some time, and it's the rule today, and I think it's always been a rule that it takes a while for these cases to get there. Albion Tourget, however, never, to my knowledge, set foot in the South again, and he's certainly not in New Orleans during the time the case was being litigated. And the mails were notoriously slow. And as a consequence, his litigating the case also had a time element that was added. But I don't know if that really explains why it took so long for it to get there. I also want to mention there was another lawyer, another white lawyer who was engaged in the case, and that was Samuel Phillips. And I have to mention him because I teach at the University of North Carolina at Chapel Hill, and Phillips and his family were very much part of the University of North Carolina at Chapel Hill, but he also served as the Solicitor General of the United States for quite some time, one of the longest serving Solicitors General. So he also became persona non grata in the South, and then and had to move to Washington, D.C., and did, and worked most of his life here in Washington.
We met Samuel Phillips in an earlier case. He was the Solicitor General during the civil rights cases.
That's right.
And argued the case on behalf of the United States and lost. Went into private practice and then joined this case as a private practice lawyer. Another person that belongs in the civil rights history annals in our country. We're going to take a couple of calls, and then we're going to move on to the case as it was heard before the Supreme Court in 1896. First up is Charles in Massillon, Ohio. Hi, Charles. You're on the air.
Well, thank you. There's been a lot of discussion recently about Jim Crow laws. Who is Jim Crow?
All right, thanks. What is the origin of the name Jim Crow applied to those laws?
Well, I don't know that I would claim to have the best understanding. I think it's a nickname that was given, but I don't remember all of the origins of this nickname for segregation, for what used to be called a little earlier in the 19th century black laws or black codes. But the term Jim Crow was coined at some point, and it stuck.
Next is Bob watching us in Houston. Hi, Bob. Bob, you're on the air.
Oh, this is Josh.
All right, Josh is in Algona, Iowa. Welcome, sir.
Hi, you guys. I just have two questions. First, when Plessy was decided, was there any national outcry denouncing the decision? And secondly, were there laws passed nationally right after the Plessy decision was handed down?
There was almost no immediate reaction to the Plessy case. There was very little reaction. I know there were some newspapers in the North that commented on it in Brooklyn and Chicago, et cetera. They didn't have a whole lot to say about it. There wasn't a national outcry. And if you had told somebody that we'd be sitting here 100, some odd years later, talking about it as a landmark case, I don't know that they would have recognized it for that purpose. As to whether there were national laws passed. These were state laws that were being passed, and I don't think Congress was engaged very much in passing laws with respect to racial segregation at this time. Although I'm sitting next to someone who may know more than I know about that.
So on the point about Northern reaction, the New York Times reported it on page 3 in a column on railroad news. They weren't even thinking about it as a civil rights issue. And I think it's exactly right. We wouldn't think of Plessy as a landmark case had it not been for Brown. It's not like there were black newspapers that were critical of the decision, but it's certainly not the case that most white Americans were surprised, and they certainly were supportive of what the court was doing. Congress wasn't going to pass any civil rights legislation for another 60 years. That was just not even in the cards. There were white Southerners who wanted Congress to do negative things on civil rights. So when Democrats and the South kind of took over Congress and elected Woodrow Wilson in 1912, there was some discussion about repealing the 15th Amendment, which guarantees black suffrage. Woodrow Wilson introduced racial segregation into the federal civil service. But I'm not aware of any effort to pass a national segregation law. You wouldn't have thought Congress had the authority to do something like that. This was something that the states would resolve. Yeah.
And it would have been superfluous. The South had their laws in place. It was upheld by the Supreme Court, and segregation became the law of the land in the South.
Mari Lane on Twitter makes this point. Landmark, given that Louisiana has a unique civil law tradition, such a statute would be hard to challenge. What is particular about Louisiana's law and its traditions?
Well, it's a code state. That is to say, it traces its legal system to France and not, to England, like the rest of the United States. And so I think that's the reference that the commentator or the questioner is making. I'm not sure how that would have impacted, how this case played out. I don't know that it would have.
No, I mean, Louisiana is subject to the 14th Amendment the same way as everybody else, and other southern states had passed very, very similar statutes. So I think Louisiana was distinctive in some ways. There were some different rules with regard to slavery, for example. Slaves in Louisiana often had a stronger case in their freedom suits than slaves in other southern states that didn't have the Napoleonic Code background. But on this issue, I don't think there would be any difference.
Ironically, Louisiana was also the state that was involved in the first case that interpreted and applied the 14th Amendment, the slaughterhouse cases. But that's coincidental.
We're talking about Plessy versus Ferguson, 1896. Bob is up next in Houston. Thanks, Bob, for waiting. You're on the air.
Yes, really enjoying this discussion about a really important case and that has some implications for that. One thing I would like to ask you folks, there had been a mention there about the question of interstate railroad travel and how it affected the rulings on the rights of black people to sit in white, so-called white compartments. Were there any restrictions that came up under other cases on banning segregation in interstate travel, or were there any attempts made to introduce such a ban?
Okay.
So one of the first federal regulations that applies to railroads is the Interstate Commerce Act of 1887, and there had been discussions during the congressional hearings on that about regulating the issue of segregation. The final version of the statute forbids undue or unreasonable discrimination, which is mostly about the rates that are charged by railroad companies, but the Interstate Commerce Commission had actually adjudicated some cases on the issue of whether the prohibition on undue or unreasonable discrimination, whether that forbade segregation. And the Interstate Commerce Commission had ruled you've got to allow African Americans to travel, but segregation is not undue discrimination So the Interstate Commerce Commission had actually ruled in favor of the practice of segregation.
Solomon is up next, Washington, D.C. Hi, Solomon.
Yes, good evening. My question is, did the Taney Court, Dred Scott decision, have any bearing on the decision for Plessy? And if so, I would like to know. Thank you.
Well, Taney's court, of course, decided the other most infamous case. Some people call this in legal academia, and we don't want to get too much tied up in that here, but called those cases the anti-canon, some of the worst cases. We're not proud of them. So Dred Scott, certainly Taney says that and wrote that black people had no rights that white people were bound to respect. And quite gratuitously ruled that black people could not be citizens of the United States, whether they were slaves or free. So here we have the court in 1896 deciding that separate but equal was unconstitutional. The two cases, to the extent that they have a relationship at all, are related perhaps in the fact that they are two of the worst cases that the Supreme Court decided, and it deprived African Americans of basic and fundamental rights. There's no, I don't see any legal connection between the two cases because Dred Scott, of course, was overruled by the 13th Amendment. One could point out that the 13th Amendment was part of the argument that was being made along with the 14th Amendment in the Plessy case. But other than that, I'm not sure that I think that the two are related.
Could I just add something? It's not inconsistent at all. I agree with what Ted said. I think it's important to note that the Dred Scott court was dominated by Southerners. There were 5 Southerners in Dred Scott, and the Plessy court is actually controlled by Northerners. So it's kind of stunning that even a court with a majority of Northerners is so unfriendly to the rights of African Americans. And then the other point is, if you took a referendum vote of Americans at the time of those decisions, both of those rulings would have been more popular than not. So we regard them as outrageous decisions, and of course they are, given our values today. But most white Americans, which is most Americans in 1857, agreed that African Americans didn't have constitutional rights, and the overwhelming majority of white Americans in 1896 favored racial segregation. So these are court decisions that are very consonant with the dominant mores of the age, but our views have thankfully changed since then, so we're able to criticize those decisions.
The court heard the case in April of 1896. This is the room inside the U.S. Capitol. The court did not have a home of its own at this point in history where the court sat. Today it is set up as the old Supreme Court chamber, or excuse me, the old Senate chamber. But the court was meeting in the Capitol in this space. And we're going to talk a little bit about the justices on the court. The Chief Justice was Melville Fuller. He's one of 3 Cleveland appointees, along with Edward White, who had been previously a Louisiana senator and later nominated by Taft to be Chief Justice, Rufus Peckham, who was nominated by Cleveland in his 2nd term in office. The Harrison appointees were, these are the Republicans, David Brewer, who was a nephew of Justice Field, and he did not participate in the Plessy case. Henry Brown, who ended up writing the majority opinion in this case, and George Sherris, a Harrison appointee. One Lincoln appointee still on the court, Stephen Johnson Field. He had the 2nd longest tenure of any justice on the court, 1863 to 1897. An Arthur appointee sat on the court then, Horace Gray, and John Marshall Harlan. We've talked about him in past cases, and he wrote the lone dissent in this case. What else should people know about this court, the Fuller Court?
Well, Harlan is the dissenter and sort of unpredictable as a dissenter, given that he had been a Kentucky slave owner before the Civil War, and he had opposed the 13th Amendment as a congressman from Kentucky. The 13th Amendment is the one abolishing slavery. And then he'd opposed civil rights legislation in 1866 and 1875. So it's a little bit ironic that Harlan is the one dissenter, although it's worth noting that we know from other evidence, other opinions that he wrote in extrajudicial writings, that even John Harlan would have had no problem with state-mandated segregation of education. He distinguished state-mandated segregation of railroad passengers. Justice White, so maybe it's worth noting that you didn't have a Democratic president all the way from the Civil War until 1884. That's the first time that you could get Southerners on the Supreme Court again. And one of those Southerners is Edward White, who had been a Confederate soldier and had apparently belonged to Klan-like organizations in Louisiana in the years after the Civil War. So it took a long time for the South to make a political comeback after the Civil War, but finally they're getting justices, and some of them are ones that we wouldn't feel very comfortable with. But even the Chief Justice is a Democrat who had opposed Lincoln's Emancipation Proclamation during the Civil War, and had actually played a role as a Democrat during the Civil War in segregating Chicago's schools. So some of these justices don't have very attractive backgrounds from our perspective. I don't know how much it matters whether they're Democrats or Republicans. The Republican Party was giving up on its commitment to protecting the civil and political rights of Southern blacks. So Justice Brown ought to have been someone who you would expect would be supportive of civil rights. He comes from Massachusetts, the cradle of abolitionism. But even Justice Brown, who writes the opinion, is fine with racial segregation.
Well, the other thing I recall is that the late A. Leon Higginbotham, Third Circuit African-American judge, and also an author and scholar on race in the colonial era. But I remember him saying that if you looked at that court, the dissenter, Harlan, was the only one who didn't go to one of the top law schools, Harvard and Yale, etc. All these other justices on that court went to some of these, in quote, best schools. Harlan comes from Kentucky, was educated in Kentucky at, not at an Ivy League school, but he was the one who dissented from the separate but equal ruling.
As we said, the Albion Tourget was the lead counsel representing Homer Plessy before the Supreme Court. We're going to return to the McClurg Museum in Westfield, New York, which has a collection of Tourget's papers, including some from his work on Plessy versus Ferguson. Let's have a look.
In our archives, we have this is the actual document that he held and read at the Supreme Court. It's 45 pages long. We don't know that he ever actually got through it all because they stop and ask questions, and this was a pretty lengthy thing, and so we're not even sure that he made it through the whole thing at the Supreme Court.
45-page oral argument. You said at the outset that he based his challenge on the 13th and 14th Amendments. Can you give us a synopsis of what kind of arguments he made before the court?
The 13th Amendment is the argument that racial segregation is one of the badges or incidents of slavery. So the 13th Amendment forbids slavery, but it's also interpreted to allow Congress in enforcing it to go somewhat broader, or a court enforcing it to go somewhat broader, but not so far as to have a ruling on segregation. Segregation is not, they said, a badge or incident of slavery. On the 14th Amendment, the argument is the government's not allowed to know the race of its citizens. Government has to be colorblind. And that being able to travel on a public accommodation without being insulted because of your race is a basic civil right. And the 14th Amendment guarantees that all people in the United States, not even just citizens, are protected in the equal protection of the law. So that's basically the argument.
The Supreme Court today hears oral arguments, about 70, 75 of them a year. They're, for the most part, confined to 1 hour. What was it like back then?
I don't know whether, I can tell you earlier they would sometimes spend days arguing cases, but I don't think that's true by the 1890s. And Plessy is not regarded contemporaneously as a big deal, so it's not like a case where you would allocate an extraordinary amount of time. It's just a routine railroad regulation case, so I imagine they're getting an hour or something like that. In the 1830s, Daniel Webster would stand up and they would have arguments for 3 days, but they didn't rely on briefing then. It was all done through the oral argument.
I think that's right, although when Brown was argued in the 1950s, Brown was one of these cases that was argued over a number of days, and of course it was argued twice. So there were cases that were argued for and over days, although I agree, I doubt that Plessy would be one of them.
For the state of Louisiana, Alexander Porter Morse argued for the state, and it was his one case before the United States Supreme Court. We're going to take some more phone calls, and then we'll come back and learn about the decision, which was handed down a month later in May of 1896. Let's hear from Cece in Portland, Oregon. Hi, Cece, you're on.
Hi. I have two questions. One for Dr. Shaw. Wanted to know how the Plessy case is taught in law schools. What are the lessons or legal issues that you want students to learn from the Plessy case, and just the prominence that it has in law school curriculum? What role does it have? What lessons or ideas are you trying to bring across to the students? And then the other question is, how are people, jurists today who define themselves as strict constructionists, how do they view the Plessy decision? How do they interpret it, or how do they just wrestle with it in their mind with that point of view of being an originalist or strict constructionist?
Well, with respect to the first question, of course, how it's taught in law school depends on who's teaching it. And I know when I was in law school a long time ago, certainly we were taught that Plessy was not a decision that the court made which stood up over time. Although after Brown versus Board of Education was decided in the 1950s, 1954, there were scholars who said that Plessy, in fact, was decided on grounds that were pretty solid, and that Brown's grounds weren't decided well. The way I teach Plessy, there are a few things I want to get out of it. One of it is that it is the capstone case of the redemption era, the era that ended Reconstruction. And if you read the decision, one of the things about it is that there's this element of intellectual dishonesty in the decision that I point out to students. Justice Brown at one point talks about the implication that was argued that separate but equal stigmatized black people, and he said that to the extent that there's any stigma imputed by the law, it's not because the law did so itself or was intended to do so, but because black people interpreted it that way. So it's a kind of a blaming the victim phenomenon in the case. The other thing that I think is important, there's so much more we could say in talking about Plessy, but Harlan's dissent is the thing that perhaps survives most. And that deserves some attention. I'm sure we're going to talk about his dissent, and so we'll get to that. But I think it's important also for law students to understand that there are twists and turns, and we can't ever think that because a case is decided in a particular way or a constitutional matter is resolved, that it's resolved for all eternity. That isn't necessarily so. And that's part of what we see when we see Plessy, and I'll wait until we get back to the dissent itself. As to your second question, I think I'll probably turn that over to my colleague here.
I think the question of racial segregation is a real problem and always has been for originalists, and it's because of something that Ted alluded to. We all assume that Brown is obviously right, but as a matter of the original understanding of the 14th Amendment, Brown is actually somewhat problematic. And we are going to talk more about that, but the people who wrote the 14th Amendment for the most part, if you asked them, would have denied that what they were trying to do was require school integration or railroad integration. They were trying to prevent the recently freed slaves from being denied basic rights of contract and property and legal protection. They actually weren't trying to do things like desegregating the schools. For example, the same Congress that wrote the 14th Amendment also ran the school system in the District of Columbia, and they segregated it. So originalists want to be able to defend Brown because we all regard Brown as just and heroic and obviously right. And if the original understanding of the 14th Amendment doesn't justify Brown, that's a problem for originalists. So I think they've gone to heroic efforts to tell a different sort of history. They're happy to dismiss Plessy. They would say, obviously, Plessy is an example of why you should be originalist, because Plessy is the court reflecting the contemporary mores of the time and departing from the original understanding. The problem is they're assuming that the original understanding of the 14th Amendment was desegregation, and I don't think that's actually the best historical rendering of what the people who wrote the 14th Amendment were trying to do.
Seth is in Chapel Hill. You're on the air. Welcome.
Oh, I actually have a question about Harlan's dissent, and it is apparently sort of what is the preferred doctrine of today, but I'm wondering if you could talk about some of the potential issues with his opinion, including some of his racist language, where he talks about whites being clearly superior, and then this idea of the colorblind Constitution and no caste being here.
Great, thank you. I want to put up some language from the majority opinion and Harlan's dissent, and then we will answer his question. So it was a 7-1 decision in May of 1896. As we mentioned, one justice not participating, and the one vote dissent was Harlan's. Justice Brown wrote the majority opinion, and here's a bit of what he said. In the nature of things, it could not have been intended to abolish distinctions based upon color or to enforce social, as distinguished from political, equality, or a commingling of the two races upon terms unsatisfactory to either. What are you hearing there, legally?
Well, I smiled for a moment when you read that language. That language always sticks out for me, in the nature of things. It's loaded, but it also reminds me of another case most Americans don't know about involving women, Bradwell versus Illinois, and the question of whether or not a woman could be a member of the Illinois bar, and the court ruled that she couldn't be. But there's also that phrase in that opinion, in the nature of things. So the assumptions about African Americans and Plessy and women and Bradwell were loaded assumptions that reflected the bias that was the rule and not the exception of the time. But the language in the dissent about colorblindness has had such power, staying power, that many people believe that it is, it has the force of law. We should talk about that language. The idea of the colorblind Constitution is very appealing. It's a very eloquent, it's very eloquent language. But the Supreme Court has never ruled that the Constitution requires colorblindness in all respects. Although many people act as if it does, including some of the justices on the Supreme Court. So we should have a little bit more discussion on that, perhaps.
Here's exactly what he wrote. Our Constitution is colorblind. This is Justice John Marshall Harlan in his dissent. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. On that phrase, we should note that it was actually Albion Tourget in his argument who used the colorblind phrase, and Justice Harlan picked it up in the dissent. Can you talk about that?
Albion Tourget is a lot more committed to a strong form of racial equality than Justice Harlan is. I think it's important to emphasize all of these justices are likely supportive of white supremacy in some form, Harlan was a slave owner. He's an opponent of emancipating slaves in the 13th Amendment. He's an opponent of civil rights legislation. He does, as Seth points out, he does say racist things in his opinion. He believes that all men have race pride. He believes that the white race will continue to exert its supremacy, but that it's a mistake to use law to accomplish that through segregation. And he says some extremely racist things about Chinese Americans as well. It's just a mistake to think in 1896 that there are any neo-abolitionists on the Supreme Court. They think interracial marriage is a bad thing. Most of them don't believe African Americans ought to be voting. They don't believe they should be serving on juries. The President of the United States is declaring sectional reconciliation, which is achieved at the cost of the rights of Southern blacks. Teddy Roosevelt, a few years later, is going to talk about the importance of race purity being maintained. This is what most white Americans believed, and the justices are a reflection of that. We know John Marshall Harlan would have been fine with school segregation. He just happened to draw the line at state-mandated segregation of transportation.
We had an earlier caller who asked what strict constructionist view of this case would be. In 2000, Justice Clarence Thomas talked about the Plessy decision. Let's listen to some of what he had to say.
People look at the court in kind of a current events mode. Our work is long-term work and has to have a much longer shelf life. If you look at the first Justice Harlan, he was a sole dissenter in Plessy versus Ferguson. Look how long his opinion's shelf life was. His dissent, it has to be almost timeless.
He argues that the court needs to take the long view. The court, I mean, what are your comments when you listen to that?
Well, I have a couple different reactions. We'd all love it if the Supreme Court played the role of heroic defender of the rights of minorities, but a Supreme Court that was so out of touch with the contemporary mores would be a Supreme Court that either destroyed itself or was overturned by constitutional amendment or would have its decisions ignored. So the Supreme Court decided in favor of gay marriage in 2015, but if they tried to do that 30 or 40 years earlier, nobody would have paid any attention. If the Supreme Court had decided Roe versus Wade or struck down the death penalty 20 years earlier than they decided those cases from the 1970s, the country wouldn't have been prepared to accept that. That's true about Brown versus Board of Education. The NAACP didn't bring a challenge to grade school segregation until after World War II because they understood, A, they weren't going to win, and B, even if they did win, the country would have rebelled against the decision. So it's nice to believe that the Supreme Court can always do the right thing, but the Supreme Court operates within the current historical and cultural context, and there's a limit to how much they can make society better than it's inclined to be.
That caller had made reference to some painful language in John Marshall Harlan's dissent, and here's a bit of what he wrote that the caller was referring to. There is a race so different from our own that we do not permit those belonging to it to become citizens of the United States. Persons belonging to it are, with few exceptions, absolutely excluded from our country. I allude to the Chinese race. But by the statute in question, a Chinaman can ride in the same passenger coach with white citizens of the United States, while citizens of the black race in Louisiana, who are entitled by law to participate in the political control of the state and nation, are declared to be criminals liable to imprisonment if they ride a public coach occupied by citizens of the white race. How should we view John Marshall Harlan?
As in some ways, a man of his time, although in some ways, to some degree, a little bit more progressive than many of the white people of his time, and certainly those on the Supreme Court. But there's no doubt, Professor Klarman mentioned it a moment ago, no doubt of that. This view, his view, with respect to Asian Americans, Chinese Americans, was just flat out racist. And already there had been a lot of litigation, or a significant amount of litigation, I should say, with respect to Chinese Americans, Asian Americans, where they stood, would they be deemed white for some purposes, etc. So it isn't like they weren't also on the table when it came to constitutional rights. But this is a very unfortunate part of this opinion. and very racist. But again, Harlan's views, even with respect to African Americans, he didn't deem African Americans to be social equals. What he was saying, in effect, was that it is unseemly and unnecessary for us as white Americans to behave this way. That there's no fear that we should have that black people are going to be our equals. It's just not going to happen. And the white race has been and always will be the dominant race. So he believed in white supremacy also.
After losing his challenge in the Supreme Court, Homer Plessy went back to his life in New Orleans. He paid his $25 fine for breaking the law. He spent the rest of his life pretty quiet, normal life, selling life insurance, and died in his 60s and is buried in New Orleans. So this did not become the centerpiece of his life for the rest of time. We're going to take some more calls, and then we're going to learn about what this decision meant for life for African Americans in our country. Let's hear from Jim in Omaha. You're on the air.
Yeah, thank you for taking my call. I've been watching you guys for 3 weeks. I'm learning something new from you, the moderator, and your guests, just like the two guests tonight. I'll tell you what, one of the things I am learning is the history of our country, the understanding of these, the 13th, the 14th, the 15th, the construction amendments, Reconstruction Amendments, and the idea of our founders that when they did what they did at the convention in 1787, knowing that they had an issue with slavery, knowing that they would like to see it be fixed in the future. I would think that all this stuff that's going, even with the Jim Crow laws, all these three amendments, what you guys have been saying tonight, I guess it was really tough in that time frame of our history for the people of different races to understand. I guess what I'm really getting at is the 14th Amendment, knowing that because of Dred Scott is why we got the 14th Amendment, knowing that we wanted to give them citizenship and that we all should have worked together, and then it shouldn't have taken until 1964 for the Civil Rights Amendment just because of the Jim Crow laws. If you understand what I'm getting at, and I would like to hear the two gentlemen comment on it.
Teshal, you want to start?
Sure, and thank you for that comment. Certainly, I think we should understand the three Reconstruction Amendments, the 13th, 14th, and 15th Amendments, as being a kind of a second founding. I like to think about those who advocated for it as being a second generation of founding fathers and mothers, because they were women who were engaged in advocating for the 14th Amendment, although women found themselves to be terribly betrayed when it came to both the 14th and the 15th Amendments in some ways, in profound ways. But I think that the country was remade by the Civil War and after the Civil War, and I think that's what the caller in part is referring to. I would add that it's important to think about the relationship between the post-Civil War amendments, and particularly the 13th and the 14th Amendments, which were argued in tandem. And I think that one of the things we've lost through the Supreme Court's cases is this relationship and understanding of the relationship between the 13th and the 14th Amendment. The 13th Amendment wasn't only about ending slavery, although the court seemed to have said that in the civil rights cases, but also was about the badges and the incidents of slavery. And that somehow was lost by the Supreme Court. So yes, it took us another 100 years after these post-Civil War amendments to really breathe life into them. And Brown was a key turning point, and Brown, of course, in part, sounded the death knell, although it didn't kill it completely for Plessy versus Board of Education, but it was the death knell of Plessy.
Michael Klarman, you literally wrote the book From Jim Crow to Civil Rights. So what would you say to that caller?
I think it's important to see that you make progress and then there's backlash against the progress, and that people are invested in the status quo and they don't give up that investment easily. The 13th, 14th, 15th Amendments were about trying to give African Americans basic civil rights, voting rights, ending slavery. But during Reconstruction, there was a serious effort made at racial progress. African Americans turned out to vote in large numbers. They elected large numbers of office holders. They got access to public education for the first time ever in the South. But white Southerners were prepared to fight against that, and ultimately they wore down the will of white Northerners, which had never been that great, and Reconstruction was ended, and there was a period of Jim Crow, and then you had a second Reconstruction, but the second Reconstruction also produced backlash, and I think it's important to see that it's not like the struggle has ended. Today you have mass incarceration, and you have separate and unequal schools, and you have poverty and segregation, and the struggle goes on, and there's always resistance to change.
We said that earlier, that the decision really was not widely noted at the time because it reflected the view of the majority. And here's just one article in a Kentucky newspaper: separate coaches held to be constitutional by a U.S. Supreme Court. You can see not even a big headline on the story when it was published. Joe Paulson writes to us on Twitter: inequality two-step. Civil rights cases says there is not enough state action to uphold congressional law to stop discrimination. Plessy, he writes on Twitter, says even with a state law, it need only be separate and equal. Next up is Nanbita in Chicago. You are on the air. Welcome.
Hi, thank you for having me, Susan. So there's a lot of discussion around how rulings from the Supreme Court can deny Americans rights that they should have. And you mentioned how diversity could play a role as well, so the percent of Northerners, Southerners, level of education, etc. So how do you think that the current demographics of today's Supreme Court could impact some of today's rulings, taking into account factors like gender, ethnicity? And how can we as Americans encourage a diverse set of justices, given that they are lifetime appointees, that, we don't have the same situation that they had where Americans are being denied rights because it's not of the time? Thanks.
Thank you. You want to take that?
Sure. I think Supreme Court justices in their constitutional rulings always reflect their backgrounds and their political beliefs, their ideological views. One thing that's distinctive about Supreme Court justices is that they tend to be very well educated, reasonably affluent, and for the last few years they've all gone to Harvard or Yale law schools. That actually has an effect. One reason why the Supreme Court in the last 50 or 60 years has been perhaps more liberal on cultural issues than the average American is because very well-educated, relatively affluent lawyers are much more progressive in their views on abortion, much more committed to the separation of church and state, much more progressive in their views on sexual orientation and supportive of gay marriage. I think that's a good explanation for why the Supreme Court decided Brown at a time that the country was still very divided on race, why the Supreme Court struck down school prayer and ruled in favor of abortion rights and struck down the death penalty. I think what's happened in the last 30 or 40 years is that the political parties have understood that the Supreme Court is very, very important for them to control, and to some extent they've been able to nullify that progressive bent that well-educated, relatively affluent lawyers tend to have. So now what you're going to get is reliable liberals appointed by Democrats and reliable conservatives appointed by Republicans. And after Senator McConnell refused a hearing to Barack Obama's effort to replace Justice Scalia, the Republicans have managed to keep control of the Supreme Court, which they've basically had for the last 45 years. And that has a big effect. It has an effect on issues like gun control, race-based affirmative action, campaign finance reform. And I think you're going to see less of the bias of elite lawyers and more predictable political decision-making by people who were appointed by parties for a particular reason.
If I may, I want to point out another factor, at least with respect to the demise of Plessy. Although the court never said a word about it in Brown, we have to understand that Brown was decided during the Cold War. and you had America after World War II in this Cold War, this battle with the Soviet Union, with this tremendous flaw that was evident in the United States. How does it claim to be the beacon of democracy, and at the same time, even after it fought a war against European racism against Jews, at the same time it still has segregation in place, intact? Plessy had to be abandoned when it was abandoned, and in part it wasn't just a matter of law. It was a matter of the geopolitics of the time that pushed the court to where it went in Brown when it went there.
James is in Greenfield, Massachusetts. Welcome to our program on Plessy versus Ferguson, 1896.
Well, thank you very much, Susan. I got two questions that really interest me about this discussion tonight. Is the people who actually planned the court case, before who gave birth to this case, before Albion Touche and Samuel Phillips. Can you give me some kind of a idea of what these people think, who they were, how many of them, were any women there in that decision? Were there any blacks or whites? What was the makeup of that decision? And the other thing was seeing that Justice Brown tonight delivered the opinion of the court. He was a native of Massachusetts. He refers in his decision to the early case of Roberts versus City of Boston. And I wonder, can you explain how that played a role in this case as far as he was concerned?
Thank you.
Thank you very much.
Thanks. In the interest of time, I'm going to have you answer the first one and you answer the second one. So he's basically asking about the Citizens Committee and whether or not there were women involved. Can you tell us any more about the group that challenged this?
It wasn't a huge group. I think it was, though Michael, correct me if I'm wrong, it was somewhere between 15 and 20. And as I said earlier, there were these African Americans who were part of this middle upper class group of people, light skinned, privileged, etc. But they understood that they were going to be treated the same way as dark skinned African Americans, and so they wanted to challenge this law. I think the group was interracial, although it was perhaps more made up of this light skinned African American component of the group, but they knew that their lives were going to be very heavily circumscribed by this law and its implications in other areas of life.
Justice Brown's decision and the City of Boston?
Right. There's a case from about 1849 or 1850 when Charles Sumner, who later was one of the great radical Republicans who really did believe in a strong form of racial equality during Reconstruction, he was arguing against school segregation in the city of Boston. He was invoking the free and equal provision of the Massachusetts Constitution, which is the same provision that the court in the 1780s had used to abolish slavery in Massachusetts. And he was arguing school segregation is inconsistent with the free and equal provision of the Constitution. And the Massachusetts court, per the great state Supreme Court Justice Lemuel Shaw, said no. Said separate but equal is consistent with the Massachusetts version of the Equal Protection Clause, and that seems significant because Massachusetts is the state that you think of as the cradle of abolitionism, but even Massachusetts seemed to think segregation was permissible under a state analog to the Equal Protection Clause.
Let's talk about the legal implications of the Plessy decision. For example, on Twitter, Doc Darnell tweets this question: did the Plessy case affect other races and separate but equal laws? For example, American Indians or Asians? If so, how? Let me add to that, and I'll have both of you answer. How often was Plessy cited as people challenged Jim Crow laws in the early part of the 20th century? What was the legal standing and really its impact over time in the early part of the 20th century?
Well, in the very beginning of the early 20th century, there remained a number of cases in the South that involved jury service and voting. A few of these cases, 1901, 1903, etc., those weren't successful for African Americans. And there was a long, dry spell with respect to using the 14th Amendment for its original purposes, that is, protecting African Americans. So in 1917, there was a case that came out of the city of Louisville involving housing segregation. Ironically, or maybe not ironically, the plaintiff there was white, and he was trying to sell his home to an African American man, and he prevailed in his challenge to the city, saying that they were discriminating, and so he prevailed under 14th Amendment. For the most part, the 14th Amendment didn't have a whole lot of force until the plan that the NAACP and the NAACP Legal Defense Fund devised when they began to challenge separate but equal, and began to challenge it using the fact that we alluded to before. The railroads didn't like segregation in Plessy because it cost too much. Well, separate but equal education, particularly in higher education where they first began to challenge segregation, was tremendously expensive. It was never meant to be equal. It wasn't going to be equal. And so strategically they began there. But that wasn't until the late 1930s and into the 40s that those cases began, and that was the road to Brown versus Board of Education.
Comments on Plessy's importance to the law for the next several decades?
So two things. One, in a place like California, where they barred segregation of African Americans in their constitution starting around 1880, they mandated segregation of Asian Americans. In southern Texas, they certainly mandated segregation of Latinos. But I think it's a mistake to think that that somehow was inspired by Plessy. Segregation laws were adopted before Plessy. In California, as I said, it was 15 years before Plessy that they started segregating Asians into separate schools. So I don't think it was necessary for people who were inclined to adopt segregation to have the Plessy decision, but certainly other races and ethnic groups were segregated. In California, it was much more important to people to discriminate and segregate against Asians. Asians were 10 times as populous in California as African Americans were in the mid-19th century. So it was Asians that they were mostly concerned about, and they certainly segregated them in separate schools.
Although there was a case, Gonlam versus Rice, in which in Mississippi in the early 20th century, in which a Chinese American man sued to challenge the segregation laws as applied to his daughter because they were assigned to schools for black folks, and he wanted them to be able to attend a white school because they were better schools, etc. He lost. So, you know, the irony is that segregation played out in all kinds of twisted and ironic ways when it came to people of all races. In 1947, there was a case in California on the state law that involved segregation of public schools called Mendez. And without going into the details of how that was decided, it ended up that the Mexican-American children were had to be admitted to the predominantly white school because the law didn't support the segregation there and the state law in California.
So our guests have explained how it took to 1954 in the Brown versus Board decision to unravel Plessy versus Ferguson. Here's a little excerpt from that decision. We conclude, says the Supreme Court, that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. And you talked about how it's important that that focused on education in that case. And then also by 1964, the Civil Rights Acts were the next nail in the coffin for Plessy versus Ferguson. Here's a little bit of what the Civil Rights Act did. It banned racial discrimination in hotels, restaurants, and other public accommodations. It prohibited unequal application of voter registration requirements and prohibited segregation in schools and jobs. So the legal framework was there, but what was life really like for people in this country in the 50s and 60s, even with these laws and these Supreme Court decisions enacted?
Well, from the time that Plessy was decided, and frankly even before Plessy was decided in many respects, African Americans lived segregated lives in which they were treated as racial inferiors. When we think about the history in this country of slavery, I think we have to think about a continuum right on through Jim Crow up until the 1950s, Brown versus Board of Education. But even beyond that, I think we have to talk about in through the 1960s. It wasn't until 1964 that the Civil Rights Act was passed and employment discrimination was illegal, and discrimination in public accommodations or in federally funded programs wasn't until 65 the Voting Rights Act was passed. Not until 67 that the Supreme Court struck down laws that banned interracial marriages, and not until 68 after the assassination of Martin Luther King. We're 50 years out from that assassination, almost to the day soon. And you know, it wasn't until then that the Fair Housing Act was enacted. And so for black people during this period of time, but also for other people of color, they lived with the rule of white supremacy. If it wasn't explicitly articulated in all respects, being the rule in most respects. And so it took until the civil rights movement of the 50s and 60s for that to be changed. And to be clear, even today, we still struggle with all of these issues, even though we've made tremendous progress in the United States.
So the Brown decision was massively resisted by the white South. Very little school desegregation took place in the 10 years after Brown. The civil rights legislation that Ted was referring to is incredibly impactful, and it's a function of the civil rights movement. Brown did not desegregate many schools until the federal government in the 1964 Civil Rights Act threatened to take away federal education dollars from school districts that continued to segregate. The 1964 Civil Rights Act and the public accommodations provision was very effective. To some extent, there was a kind of collective action problem. There were lots of Southern owners of businesses who actually wanted to sell to black people, but they were worried that if they were the first to do so, they would lose all of their white customers, right? I mean, black businessmen who are in business to make money would like to take the money of black people, but if they're worried that their white customers will leave because they don't want to sit down at a table next to a black person. So the federal government could solve that problem by telling everybody, you know, there is no first mover, all of you have to desegregate at the same time. That was actually pretty effective. And the Voting Rights Act was incredibly effective. In Mississippi, you go from fewer than 6% of African American age eligible voter registered people to 60% within a couple of years. The federal government, Congress, can act in really efficacious ways. The Supreme Court itself depends on other federal actors to enforce its decisions. So these civil rights laws were incredibly important to the racial progress that was made.
At the beginning of our program, you met Keith Plessy, a descendant of Homer Plessy, the defendant in this case. On the phone with us right now is a descendant of the judge, Judge Ferguson. Her name is Phoebe Ferguson, and she joins us from New Orleans, where today she is the executive director of the Plessy and Ferguson Foundation. An interesting kind of coming together of two characters in our history. Phoebe Ferguson, how long were you aware of your ancestors' role in this important case? Was it something you grew up knowing about?
Good evening. Actually, no. We were unaware of our connection to Judge Ferguson and only became aware of it in about 2002 when a gentleman had bought his former home here in New Orleans and wanted to restore it to its original Martha's Vineyard architecture. And so he finally found my number apparently after 10 years of looking. And, he said, I bought your great-great-grandfather's house, the judge in Plessy versus Ferguson. And so I happened to have a family tree that had been given to me, and I quickly took it out. I looked down, and there it was. And that was the beginning.
How did you go from that surprise revelation to meeting Keith Plessy?
Well, I began to search and research and look up things, and quickly found that a book had recently been written by a local historian here, Keith Weldon Medley, and the book was entitled We as Free Men, Plessy versus Ferguson, The Fight Against Legal Segregation. And in that book, he had written an entire chapter about Judge Ferguson, which was very unusual for anyone to actually research who he was. Of course, the book is about all the characters in detail, who all the Citizens Committee members were, who Homer Plessy was, who Judge Ferguson was. And so he had met Keith already, and when I called him, he just, fell off his chair. He had both of us now, and he set up a surprise meeting. And so I came to New Orleans. I was in New York at the time. He came to New Orleans and met Keith, and I introduced myself, and he introduced himself. And as Keith likes to tell the story, I just started apologizing not only for my ancestors' role in the case, but for slavery and pretty much all racial injustices thereafter. And Keith just laughed, and he said, it's no longer Plessy versus Ferguson. It's Plessy and Ferguson. And we've pretty much been friends ever since.
So what is the work of the Plessy and Ferguson Foundation? What do you do?
Well, so we teach the history of the case and, why it's still relevant in today's world. We go to schools and teach the case to young kids, as young as second grade and up to university level. We have a day every year where we honor Homer Plessy, which was the day, June 7th, that he was arrested in 1892. And we put up historic markers in places of African-American resistance and achievement here in the city of New Orleans because, as is the case with Homer Plessy, or was the case with Homer Plessy, there was no marker to show what happened on that site and who the players were and how that story unfolded, and that New Orleans was, in fact, we like to think of the cradle of civil rights. So we not only honor Homer Plessy, but we also honor the other civil rights activists in the city of New Orleans, and hopefully we will expand to the rest of Louisiana and maybe the nation.
Well, thank you very much for being part of our program tonight. And it's a nice coming together on this interesting chapter in American history. And I think it's probably interesting for all of us to hear your story and to meet you by phone, descendants of Judge Ferguson in this case, and Keith Plessy. So thank you for adding to our understanding of your family history and how you are working to make the country better as a result. Appreciate your time.
It's certainly my pleasure.
We have, and the Plessy Ferguson and Ferguson Foundation has a website, so if you're interested in learning more about their work, you can find them pretty easily with a search on the internet. We have about 7 minutes left in our program. I want to take some calls because we basically laid out the whole framework of this case. I want to hear what people's questions are. Let's go to Rachel in El Paso. Hi, Rachel, you're on. Rachel?
Hello?
Yes, what's your question, please?
I had two questions. How did the passenger train case of Plessy versus Ferguson relate to schools of the Brown versus Board of Education case?
Okay, and what's the second?
And the second one is, how does Brown versus Board of Education relate to conflict and compromise in history, and what is the significance of it today?
Okay, we've done a bit of talking about that, but if you could do a summation for the passenger train case in Brown versus Board for that student caller?
Well, yeah, we have talked about the relationship between Plessy and education. And at the time Plessy was decided, it was quickly extended to almost all areas of life in the South. Brown, of course, happened to be an education case. And Brown did not explicitly overrule Plessy in all respects. But it did break the back of de jure segregation that was required and upheld under law. But there were a series of cases that were decided very quickly after Brown by the court in a very summary fashion that struck down segregation in swimming pools and in other areas of public life, libraries, etc. And so that was very important throughout public life. The other thing I think is important to remember, my colleague talked about the 1964 Civil Rights Act, but there was more litigation to desegregate. And it wasn't until the Supreme Court decided in 1971, Swan versus the Charlotte-Mecklenburg Board of Education, that desegregation of public schools in many parts of the South really happened. I have to mention that because the case was brought by Julius Chambers. I'm the Julius L. Chambers Distinguished Professor of Law at University of North Carolina, but people should know who Julius Chambers was.
I want to give special thanks to the National Constitution Center, our partners in this second edition of Landmark Cases, helping us select the cases and advising us on the legal issues behind them. And also a reminder that we have Tony Morrow's book, The Landmark Cases, which have brief summations of each one of them if you're following along on the 12-part series that we're putting together this year, and you can find easy access to that on our website, cspan.org. Manny is in Ozone Park, New York. Manny, what's your question?
Good evening. I just want to know whether or not protection in the Constitution, equal protection under law, meant something different back in the 1890s as opposed to current time. And do you see the possibility that this doctrine is also under attack given the divide in the country?
Michael Klarman.
Equal protection had a very specific meaning to the people who wrote the 14th Amendment. It meant literally that law had to be applied equally to people based on the way it was written. So, for example, if you had a law that forbade murder, you had to apply that law to protect African Americans who were killed in the same way that you would use it to protect white people who were killed. That is not the way that we've evolved the meaning of equal protection, because that understanding is simply about the way a law is applied according to how it was written, whereas we tend to think that there are constraints imposed by the Equal Protection Clause on treating people differently within the internal meaning of the law. So, for example, you don't get to discriminate against women, you don't get to discriminate against gays, you don't get to discriminate against African Americans. That's the way we've understood it, but they had a much narrower conception of what it meant. They were reacting to racial massacres in southern states, and the southern states would do nothing to prosecute the murderers of African Americans. So that's what the Equal Protection Clause was about, but it was a very, very narrow understanding.
We're going to put it on the screen because we're really running out of time here. The 14th Amendment and the portion of it that was at the heart of the Plessy versus Ferguson case. As we do that, let's listen to Mike, our last caller in Harleysville, Pennsylvania, outside of Philadelphia.
Great show. Thank you. On that 14th Amendment, let me just ask then. I don't understand why, 14th Amendment, the real genius of it is, of course, that it allows for the incorporation of, the basic Bill of Rights upon the states or into the states. And what I don't understand is how and why that was ignored for such a lengthy period of time. Really, I guess until, the 1920s or 1930s. I guess in retrospect, it seems like it should have been almost immediate. But was it the case that prejudice was just so rampant amongst the judiciary that it took, progressive judges to recognize the potential idea or the notion of incorporation?
Thanks, Mike. So let me tell you, gentlemen, we have a minute left, so 30 seconds on that very big question. You have hit upon these themes throughout the program, but it really sums up what this case was all about, Mike's question. So how would you respond to him?
So he's asking about a slightly different issue than we've mostly been talking about. He's talking about the question of whether the original Bill of Rights, which only applies to the federal government, is made applicable against the states by the 14th Amendment. Historians have disagreed about whether that was one of the purposes of the 14th Amendment. Justices have disagreed about that. Justice Black and Frankfurter had a big disagreement in the 1940s, and the court divided 5-4 on that question. Most modern historians think that the answer is yes. The people who wrote the 14th Amendment did intend to take the Bill of Rights and make them applicable against the states, but that's something that only happened in the 1960s, really, with the Warren Court. I don't see that as being the same sort of racism that led them to construe the Equal Protection Clause to allow segregation. It's a different issue.
And the 14th Amendment, by its own terms, applied against the state and should have banned racial discrimination. And it didn't for a long time for the reasons that you alluded to, the caller alluded to, and for other reasons.
Ted Shaw is at the University of North Carolina. He is the head of the Center for Civil Rights there, an expert in the 14th Amendment and civil rights law. Mike Klarman teaches at Harvard, author of the book From Jim Crow to Civil Rights, the Supreme Court and the Struggle for Racial Equality, constitutional historian and legal scholar. And we thank both of you for being here with us for 90 minutes to understand this 1896 case of Plessy versus Ferguson.
Thank you.
Thanks.
Thank you.
And now Landmark Cases are available as a 30-minute podcast. Find them each week wherever you subscribe to podcasts or online anytime at cspan.org and with the free C-SPAN radio app. Next week on C-SPAN's Landmark Cases, Clarence Earl Gideon was a petty thief who spent his time in jail studying the law. In his case, Gideon v. Wainwright, he challenged the state of Florida, which had denied him access to an attorney. The Supreme Court's unanimous decision in his favor established a broader Sixth Amendment right to counsel for alleged criminals. Watch Landmark Cases next Monday and join the conversation. Our hashtag is Landmark Cases. And follow us at C-SPAN. And there are lots of resources on our website for background on each case, where you can also order the Landmark Cases companion book and find a link to the National Constitution Center's interactive constitution. Go to cspan.org/landmark cases. C-SPAN's Washington Journal